Zarika Carrick versus Brianna Kingsley.
Good afternoon, Your Honor. Attorney Andrew Babnick on behalf of the plaintiff.
This one starts with quiet tension. Two parties facing off again. Zara KCK versus Brianna Kingsley. Both sides are clearly frustrated, and Judge Simpson walks in with that calm but commanding presence we've seen before. Right from the first second, you can sense how chaotic this case has become. Rent disputes, missed filings, mounting fees. This isn't just about paperwork anymore. It's about someone drowning in legal confusion while the other side's patience runs thin. The plaintiff's attorney sounds sharp, precise, and ready to move forward. The defendant, on the other hand, is stumbling through legal terms, trying to explain herself with an executive summary instead of a legally valid answer. That's like bringing a handwritten note to a chess match. The form matters. This setup is classic Judge Simpson territory. One side frustrated by delay, the other overwhelmed by the system. The tension's about to climb fast.
Hey, your Judge. Good afternoon. Brianna Kingsley, attorney.
Happy New Year. All right. I think the last time I was here, I was supposed to get a written answer. Did you get that filed?
I have that available. I went to have them review what I prepared for you. They weren't able to get me in. So this is what I have available today for the written statement.
No.
I have the executive summary in one page.
Executive summary of what?
Of the circumstance. You asked for a written statement. I have one.
No. Okay. What I asked for you to file is a written answer. That's under the court rule. I need to have a written answer to the complaint in a format that the court rule provides, which means you have to answer the complaint paragraph by paragraph.
Judge Simpson is spelling it out in plain English. This isn't optional. The court requires structure, not summaries or emotions. Every paragraph in that complaint needs a direct response, and the defendant's failure to grasp that shows how easily self-represented individuals can get lost in legal technicalities. But this moment also reveals something deeper, a gap between procedural law and human reality. The defendant's trying to navigate deadlines, paperwork, and legal language while juggling holidays and limited legal aid. Still, the judge must hold the line. Courtrooms run on rules, not sympathy. Viewers, here's a question for you. Should judges show more leniency to people representing themselves? Or should everyone face the same standard regardless of experience? Because right here, we see that fine line between fairness and firmness. And Simpson walks it with precision.
And you have to lay that out and attach whatever exhibits you are to it. A copy of that answer then has to be provided to plaintiff's counsel.
Thank you for educating me on the process.
Okay.
As I said, I have this prepared. I was going to have it reviewed by Miss Tanya over at Legal Aid downtown Ipsy. I saw her on Wednesday. She told me to come back on Thursday. I came back on Thursday, and they were too busy to take me in. This is what I have, sir.
Okay. All right. I'm sure over the holidays they were busy.
Your Honor, as a reminder, I know the court's hands are tied here. This is the third hearing on this file. I've got rent, late fees, and court costs up to $5,300 at this stage. And as the court may remember, there was originally a file filed by my client, improper, that I had dismissed and refiled to make sure notice was proper. So this has been dragging on for some period of time.
3 hearings in, and the plaintiff's attorney is done waiting. Over $5,300 in rent, late fees, and court costs have piled up, and you can feel the exasperation in his tone. But here's where it gets interesting. Judge Simpson doesn't rush to judgment. Instead, he decides to give the defendant 2 more weeks. That's both mercy and accountability, a rare balance. Simpson's clearly aware of procedural fairness. He won't let one party exploit time, but he also won't destroy someone who's clearly struggling to keep up. Yet there's an underlying message here. The court's patience isn't infinite. Every adjournment costs time and money. Every excuse chips away at credibility. The judge's tone says it all. No more excuses next time. You can feel that the next hearing will decide everything.
No, I know. I hear you.
Right.
Here's what I'm going to do. I'm going to adjourn this out 2 weeks. You need to get that corrected. It has to be in proper form for the court. Counsel for the plaintiff needs a copy of whatever you file with the court.
Before the next appearance.
Well, I want it filed by the 12th. I want it filed within a week. I'm going to adjourn this out 2 weeks because counsel for the plaintiff is going to have an opportunity to look at it, and I'm going to need an opportunity to look at whatever you're filing.
Yes, Your Honor.
I am not going to take any excuses if it's not here. If it's not here, I'm going to presume there is no answer, and I'm going to issue a default. Because I've given you this is the second time I've given you to go around outside of what happened in the last case. You follow me?
I apparently I didn't. My impression was that I was to show up with a written answer, and that's what I've done.
No, I have your written answer.
Sorry,
Your written answer was due by January 2nd.
where is that listed, sir?
It's right in my file. I wrote the note. I do it all the time.
May I have someone point that out to me? I'm supposed to say the third. It does appear on me.
Those are my handwritten notes right on the ROA. Written answer, January 2nd, 2024.
May I have a copy of that, sir?
You can get a copy at the clerk's office. I'm not providing you a copy of anything. I ordered it on the record, and that's when it was supposed to be here. Even if you believe that it was today, that's not an answer, and plaintiff's counsel doesn't have it. So I'm making it very specific. You will provide a written answer in conformity with the Michigan court rules. You will do that no later than close of business on January 12th, 2024.
This is where legal education meets discipline. Simpson is firm, structured, and teaching while ruling, a style that's earned him respect online. The defendant's confusion about where it's listed exposes how inaccessible the legal process can feel to ordinary people. Yet Simpson doesn't soften. He makes it clear, ignorance doesn't excuse noncompliance. In many eviction or rent cases like this, the written answer is the lifeline. It frames your defense and stops default judgment. Without it, your side doesn't even exist in legal terms. But beyond law, this exchange is human. One person overwhelmed, another trying to maintain order in a system that can crush the unprepared. Viewers, imagine being told to argue for your home using language you barely understand. Would you survive that courtroom pressure?
Yes, sir, I will.
Your Honor, is the court able to order escrows at this time? That rent is continuing to be due.
I can order escrow. What is the monthly rent?
$980, Your Honor.
That's disputed, Your Honor.
Okay, but I'm going to order escrow in that amount. Can you prorate that on a 30-day for me? Yeah.
But sir, they failed to provide a safe housing. He locked me out.
Okay, but listen. 980.
980, okay.
Well, hold on. 980. What's my prorate for January?
Well, it's $33 a day.
Okay. Escrow is ordered in the amount of $858. That's a prorated amount for January. And then in the amount of $980 thereafter. That must be paid 7 days within the date that rent is ordinarily due. Plaintiff's counsel will prepare an escrow order for signing by the court. To that effect, yes.
The ledger, the schedule provided by the plaintiff is not GAAP compliant. It does not show the total amount paid per month by who. It is an insufficient form, and I have all that here. I have a response, sir, that I think is relevant to whether the escrow starts now or in the future, because I have copy, for example, if I just may share this part. The Ypsilanti building inspector came and found 12 violations against them, not against me.
The defendant finally lands a solid punch, pointing out that the landlord had 12 code violations. That's huge. If true, it shifts part of the moral weight. Yet Simpson doesn't take the bait. He acknowledges it but stays focused on the current motion, escrow. This is a perfect illustration of judicial compartmentalization. Each claim has its own lane, and mixing them only weakens your argument. What's fascinating is how this case turns into a clash between emotional truth and legal process. The defendant's saying, they failed me as a tenant. The judge is saying, maybe, but first, follow procedure. And that's where most people lose cases, not because they're wrong, but because they're unprepared. This VO captures a painful truth. Justice is often procedural before it's emotional.
The escrow needs to be paid. I will take that into consideration in terms of any counterclaim or other thing that you're filing. But in terms of the escrow, that's what I'm ordering it.
Okay, so Ms. Mills, my caseworker at MISTA, said that I applied for state emergency relief help for the eviction when it originally started back in October, and was told that the landlord must provide a statement. The statement that they provided to the court wouldn't pass any accounting 101 course, sir. It does not show the proper.
For what? They needed to provide a statement for what?
May I hear your question again, Your Honor?
They needed to provide a statement for what? What was the purpose of the statement?
About how much rent is owed, the amount that they're claiming, the fact that they broke the lease, like their response that they sent has a schedule on it, sir. And I think the court would find it insufficient. I cannot defend myself against vague allegations and incorrect math.
The math ultimately becomes incorrect. That will be straightened out. But right now, I'm ordering escrow in the amount of $980 per month, prorated amount for January in the amount of $858. When you go speak with legal services, certainly they can tell you how to ask this court to reconsider that order. But that's what I'm ordering at this point.
Understood.
Your Honor, the 858, would you like to do within 7 days of the order?
Pardon?
You would like
payment within 7 days of the order.
What happens when I'm unable to pay because I'm indigent and disabled and fixed income? I cannot pay $980. I never did. I paid half of that with a roommate they allowed to break the lease.
This moment hits hard. The courtroom tension peaks when the defendant says she's indigent and disabled, unable to pay the $980 escrow. Suddenly, this isn't just a procedural issue. It's about survival. The frustration in her voice is real, but Judge Simpson's demeanor stays controlled. The law doesn't bend based on emotion. He reminds her it must be filed in the proper form. It's a brutal truth. The court doesn't operate on sympathy. It operates on structure. Yet her outburst, "You're turning your back on me," exposes something raw. It's the sound of someone who feels invisible in the system. Simpson's sharp reply, "Ma'am, don't play that with me," shows he won't let manipulation cloud judgment. This is courtroom balance in action, empathy without surrender, control without cruelty.
What?
Okay.
I have everything here, but you don't want to see it.
Sir, ma'am, that's not what I'm saying. I need it in the form. Oh, you're going to turn your back on me.
Yes, sir, because you disrespected me right now, and I'm vulnerable in the court system.
All right. Ma'am, first of all, so that the record is clear, I have not disrespected you.
You just did. I hear you say the things that you said was, "I'm ready when you are." Ma'am.
Ma'am.
It doesn't feel good, does it, sir?
Ma'am, don't try to play that with me. I deal with that with students all of the time. I sometimes will make a mistake, but you are not going to have me feel guilty because of that. So if you wish, if you want to make that an issue, then you make that an issue. That is not my true thoughts. Answer by January 12th, 2024, close of business as indicated on the record. We'll see everybody January 19th.
What was the time of the
2020. Pardon?
I didn't hear the time for the 19th, Your Honor. You may have
January 19th at 10 a.m.
Thank you, Your Honor.
Thank you, folks.
So how do I go? What you ordered? Now,
what do you want a copy of?
what you just ordered, what wasn't clear last time. I left here thinking that I'm supposed to come up with a written statement, which I've done and you've denied without looking at, right? I just want to know what I'm supposed to do because it is not clear.
You have to file an answer.
And when you say answer, it needs to be a specific form. What form number, sir?
You have to go and find those. There, you can go to the Supreme Court website. There's a general form of an answer, but I have to have the answer filed in compliance with the Michigan court rules.
The defendant pleads confusion, asking for form numbers, writing before leaving, and memory help. Simpson's reply stays procedural, not personal. He refers her to the Supreme Court website, orders the plaintiff's counsel to draft and submit the official order under the 7-day rule, and ensures everything will be on record. It's bureaucracy at work. Slow, cold, but fair. This moment captures why so many people fear the courtroom. Even when judges are fair, the system feels mechanical. Yet Simpson's control ensures that nothing slips into chaos. Every instruction, every order is recorded and clear. The exchange ends quietly, but it's powerful. The case doesn't explode, it resets. It's the calm after a storm, built on structure and accountability. Viewers, how would you handle this system if the rules weren't written for you?
All right, that's the first thing. And I need that by the 12th. You told me that you're in contact with legal services, correct?
I met with them once and
okay.
This week, yes, sir. That's
right. So what you need to do, and what I had indicated, is get back to them. They'll be able to assist you to make sure that it's in the proper form. All right. Have attachments to all of those and file that with the court, as well as send that to plaintiff's counsel. All right.
Yes, sir. Your Honor.
And then the other thing is, I've ordered escrow. Counsel for the plaintiff is going to be preparing that so that that order will be there. You will get a copy of that order.
Yes, sir.
And that's basically it. And then
may I have that in writing before I leave? How do I get that in writing? I have memory issues. I'm disabled, and I've already made the court aware of this. I need it in writing.
Counsel for the plaintiff, will you please prepare an order submitted under the 7-day rule to the court, please?
Yes, Your Honor.
For everything that I ordered. That way there will be written communication.
Yes, Your Honor.
I'm done. Thank you.
Not a problem, Your
Honor. Court calls the case of the...
Good day, madam.
I will. Thank you.
You're welcome. Look real cute.
As do you. Folks, I realize it's like, give me 5 minutes, please. Court stands in recess.
All right.
On this case today.
Your Honor, you had scheduled this for just a review to be brought up to date, I imagine, on what
the payment plans, yes. So how is it going?
To date, they've paid.
All right. And so how much is left owing on this?
$2,660.12.
So at $500 a month, it's going to be, oh, go ahead.
And I also have like an additional 500 monthly. When we had our case in our final judgment, I believe was.
What she's saying is we were on the case together. So when we came to court the last time, you had dismissed my garnishment. My wife's garnishment didn't go through, so hers continued. When we put the paperwork in, he made it as another case, so she's still being garnished.
Well, it's $150, so I get paid.
It's additional to the $500 that we had already agreed to. So we're trying to figure out why and if we can stop that garnishment, because we're already splitting a payment of $250 because we're on the same case for $500.
So right now he gets 500, which was the case that was judgment, and then I pay an additional 150, so a total of 650.
Okay, so hold on a second, ma'am. You pay that additional 150.
Yep.
How?
$75 is taken out of my check every 2 weeks.
Got it. Mr. Mack, you know anything about that?
Yes, Your Honor, the defendants have actually misstated the facts. There are two being judged in that case, two judges. So they are equally liable. So Mr. Ecumengapong,
Hold on, no. So how,
Because we're on the same case, sir.
sir, I didn't ask you to state anything to me. So, Mr. Mack, these parties agreed they were gonna pay $500 a month.
no, they did not.
Oh, I'm looking at it right now. I'm looking at it on September 1st of 2023. You were present in my court.
Yes.
Defendants to pay $500 per month. Defendants.
Okay, and so what I'm saying is the judgment against Mr. Ecumengapong was ordered by you at $500 a month. At the time, there was no garnishment against Mrs. Ecumengapong. That's why we sued them both individually and severally.
So hold it, when did the garnishment happen?
The garnishment happened through the Ypsilanti schools. The garnishment was.
No, when was that ordered? When did you request a garnishment? Where's Ann?
With all due respect to the court ordered me to prepare an order of garnishment concerning this here argument. And the order clearly stated, as of September 15, 2023, and no later than the 15th of succeeding months, the defendant also Ecumengapong is to pay $500 per month of penalty. And then, so,
All right. No. You can play those technicalities all you want with me, but here's the reality of it. The motion and affidavit for installment payment plans was filed in both of these defendants' names. Out of that motion for payment plan, I suspended garnishments because I would have to do that when I order the payment plan. If the order is incorrect, then I'm vacating that order.
I've got both right here.
Both what?
Separate names, separate garnishments. Both right here. Right here.
Show them this. Their motion and affidavit for payment plans. At the top, both names. It is, in fact, once I ordered it, illegal for you to garnish either one of their checks when I've suspended it.
I'm going by what the court has ordered the garnishment. You asked me a question.
Okay. If you're saying, give me that file back. And Mr. Mack, we're going to make it right. Today. All garnishments are hereby ordered suspended. As to both defendants. Defendants, plural, shall pay $500 per month as previously ordered.
Your Honor, there's something else I'd like to bring to the court's attention. Your colleague, Judge Barr, issued an order stating that Mrs. Ecumengapong would pay $150 a month. I don't know if that's
Vacated. That's not what was ordered on this case. If you want to bring that up before Judge Barr and he wants to discuss it with me as to which order will hold, you can. But I will tell you in this case that these funds are coming from, it is $500 per month. As I've indicated, any garnishment that has been issued is hereby ordered by this court suspended. Counsel for the plaintiff will prepare that order and have it on my desk by Monday morning. Thank you.
Will date of
Are we
15th,
finished?
the date of the 15th that you had ordered, and the
Date of the 15th of what? The payments? There'd be a payment 15th of each month, as it's previously ordered, but only $500.
as to both of them combined. So, and I want to get this clear, and there's no.
I think I'm very clear.
Well,
These two will pay $500 per month, Mr. Mack. That's it. There'll be no other garnishments of any personal wages or anything along those lines. Those are all suspended. You will prepare an order to that effect, my desk, Monday morning.
all I'm talking about is the mailing of it because of the issue, okay? So, these folks, they pay $14 to have some kind of expedited mailing, and they keep doing that. But I'm saying as an officer of the court, and in fairness to them,
Well, what? You now want to be fair to them?
well,
Seriously?
Judge,
He set up an agreement where we could drop something off.
Well-
He told us that we could not drop it off at his office and that he designated a specific place
yes.
and someone else to give it to.
So-
So therefore and it was only once where I did certified mail for it on the 15th to be sent to him.
Yes, and they can keep doing that. They can well keep doing that.
It costs more money to do that. The reason that we said we could drop it off on the 15th
Oh.
because we don't get it until the 15th.
Yeah.
So we wanted to drop the money orders off as soon as we get them. But he's not allowing us to do that.
Well, it isn't that, it's about dropping it off. But, you
Well,
know,
he
Judge,
instructed us.
No, here's what we're gonna do. Your $500 per month, you need to have it in cash. Defendants to pay monthly payments on the 15th of each month into court escrow.
Okay.
So you just bring it here, the $500. I don't know what their problem with taking your money. We'll be more than happy to take your money.
Thank you.
that's fine. All this is done for their convenience, that's fine.
I'm done, Mr. Mack. Have a good weekend.
Thank you, sir.
Same to you.
And just like that, another storm settles in Judge Simpson's courtroom. Across 2 separate hearings, he's handled defiance, confusion, and financial chaos without losing his footing. The lesson here is sharp. Justice is as much about order as it is about outcome. Simpson enforced escrow, demanded procedural answers, and corrected errors from both sides, even overruling improper garnishments in the later session. The through line? Structure wins. When defendants understand process, they protect themselves. When they don't, frustration turns into failure. This case isn't just about $980 rent. It's about how the courtroom demands discipline even under pressure. Whether you side with the tenant or the landlord, one fact remains. The judge kept the system upright. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.